Good evening, everyone. Yeah, so we would like to look at the what I call thematic number 2 of the. Those of you who joined our previous class, you will have appreciated that I said that we've put the whole of contract into 4 major thematic areas. So the last time we looked at matters which pertain to formation of contracts. And tonight we are looking at the terms of contract and also illegality and public policy. So as we are doing revision, what I propose to do is to quickly brush up principles with you. And at the end of the principles, we have some general questions which should help you to find out if you are able to respond to questions around this particular area of the law. And of course, as we do, if you have any difficulty regarding this, you can also bring it up and we discuss it together. I have not locked your mics yet. I trust that each student will discipline himself or herself so that your mic will be off, except where you want to speak. You raise up your hand and then you are given the platform to make your point. That way we have an orderly session. Good. So having said that, when we talk about the terms of contract, as we have learned already, we are talking about what is contained in the contract, the content of the contract. Yes, you are saying the parties have an agreement. What have they agreed upon? What is the contract? What are their respective rights and obligations? So those are the matters that we are interested in when we talk about terms of contracts or content of contracts. So the heart of the arrangement we call contract, the duties the parties have imposed on themselves, and for that matter, the rights they have conferred on themselves. Those are what we mean by terms of contract. And it's important we understand them, particularly so when these terms are not necessarily the same. Some have different weighting in terms of importance than others. And for that matter, should there be any breach, the consequences which are provoked and the legal remedies that may be assessed are different. And that is why we need to understand what terms of contract are. It is also important to note that terms of contract may be classified into express terms on one hand and then implied terms. When we say express terms, that is to say that the parties to the contract have explicitly, that is on their own, they have set out, they have stated the terms of the contract. And this was done at the time that the contract was made, the contract was formed. And it may be done in one of two ways, either by word of mouth or they are in writing. And of course, express terms put to rest any doubt or any ambiguity as what the intentions of the parties to the contract are. So let us keep that in mind. And how do you get express terms? Express terms may be incorporated or may be evidenced by signature. For example, the fact that a person has, for example, signed a document is an indication that he or she has accepted to be bound by that, as it were. And typically, as you know, the case of the Restraint and Gracob, the case involving the purchase of the cigarette vending machine, where the the woman who bought it was given a document to to sign, and the documents contain very small letters, although they could be read, but with some difficulty. And those letters were saying that the owner was more or less saying that they were not prepared to accept any liability for any damage which may occur. And subsequently, when the machine was actually installed, there were some difficulties, and they sought to place a reliance on that, yes, you signed the document, and that document represents what we had agreed about, as it were. Yeah, so let's keep that in mind. So where you have the, you have the terms reduced into writing, we don't have so much difficulty. But question is, where there's a signature of the person, it may, we could also have some challenges. It may well be that, yes, someone's was, trick or misled by fraud into signing. And certainly, as we know in law, fraud vitiates everything. So later on, when we are looking at the exemption clauses, you notice that where Curtis against Chemical Clinic Dyeing Company, the woman who had taken her wedding gown, was made to sign a document by which she was told that the laundry was limiting its liability to certain things. Later on, when she collected the gun, it was badly mutilated, and they sought to place a reliance on it. The court said that she had been misled by fraud. And for that matter, the fact that she had put a signature there, the signature did not bind her, or what we often also call the plea of non-ex factum. It is not my deed as it will. So let's keep that in mind. Of course, the express terms may also be incorporated by notice. That is also another way. And typically, when we are dealing with what do you call, like, the exemption clauses, especially where someone has sought to exclude liability or to limit liability, and it does not require the signature of the parties. Maybe some notice are just be given, just like you go to typical, like the car park, or you go to any public place, and then they put certain disclaimers or certain warnings there. So those are the things that we are talking about. And the case law, Parker against Southeastern Railway, Taunton against the Parker Shoe Lane, and all those line of cases. But the most important thing is that adequate notice should have been brought to the attention of the other part before it will be considered as part of the terms of the contract, as it were. And that was why, with respect to, let's say, exemption clause, this case of Ole and Marlborough, if you remember, the couple went to the hotel at the time that they signed up, got their room. They had not been told anything. Later on, they left their valuables in the room, went out, came back, and the valuables were not there. So they sought to find out, and eventually went to court. The hotel sought to place a reliance on a notice which they had left in the room, saying that leave all valuables with the management. Otherwise, they do not take any liability for any loss and so on. So question was whether the words in the hotel room should be considered as forming part of the contract, which have been made between the couple and the management. And the court took the view that insofar as the contract was made at the point where they were given the room, that is the reception, they could not be said to have had knowledge of whatever words which had been written on the wall in the room itself. So those words were not considered as forming part of the terms of the contract, as it were. Well, sometimes too, terms of contract especially may be established with reference to course of dealing. If the parties have dealt with one another before, and anytime that they deal with one another, they deal reference to certain do's and don'ts. Then subsequently, where they make a contract and they don't even articulate it, the court can make reference to their established course of dealing and say that these are also considered as forming part of the contract, as happened in Sperling against the Bradshaw. And that case, as you remember, the defendant regularly stored goods with the plaintiff, and anytime the goods were stored, receipts were issued containing an exclusion clause. So when the goods were damaged, the defendant sought to challenge the clause, and the court took the view that the regular course of dealing between the parties meant the exclusion clause was incorporated into the contract. And all the previous dealings, there had not been any protests. And of course, if we look at the case of a Holier against a Rambler Motors too, it also represents another example of how the court may say that by reason of your previous dealing or how you've dealt with one another, we can take it for granted that the terms which were present in your previous dealings, so far as is the same transaction, are also considered as forming part, as happened in the Holier against the Rambler Motors. And over there, the plaintiff had used the defendant's garage services for, on various occasions. But in 3 or 4 occasions in a period of 5 years, the car was damaged by fire, and the defendant sought to take advantage of exclusion clause in the invoices. And of course, the court took the view that few transactions did not amount to consistent course of dealing. But on another interpretation of the case, as later when we are discussing exclusion and the limitation clause, usually when it comes to any attempt by a party to limit liability in terms of issues of interpretation, the court adopts a very restrictive interpretation, one which will not make it easier for the person who is seeking to take advantage of the exclusion or the exemption clause to so benefit from it. So it is actually expected the way that the Holier against the Rambler Motors was, for example, decided. Now, apart from the what we call the implied, the express terms, which the parties themselves have actually given, we also have like the implied terms. We have the implied terms. So the implied terms, as the name suggests, is where the parties have not necessarily negotiated it by reason of certain things. The court will say that those terms are also considered as forming part of the contract. So when the question may arise, on what basis will the court say that by the fact that the parties have not expressly provided for certain matters, those matters are still considered as forming part of the contract? First of all, the courts there may be a legislation, as you know, terms may be implied by statute. There may be a legislation which says that for certain types of contract, certain matters should be considered as part of forming part of the contract. And typically, your commercial law or sale of goods, when it comes to the contract between a buyer and a seller, there has been a massive intervention by the lawmaker and says that certain matters, if they are not expressly negotiated and provided for by the parties, then there are certain default provisions which should apply. For example, when it comes to fitness for purpose, the fact that the item being negotiated, being sold should be of a certain quality. Okay, what quality? The sale of goods have to say that if for nothing at all, it should be fit for the purpose for which that particular thing is sold or is made. When it comes to price, if the parties have not actually negotiated, the Sale of Goods Act will provide that in every contract for sale, there's an obligation to pay or to pay price. And later on, the court may assist the party to make a determination, for example, as what price and so on. Not only the Sale of Goods Act, so many other legislation. When it comes to even a contract between employer and employee, if you take the Labor Act, right, there are certain matters. If you're having any contract between an employer and employee, those matters are supposed to be considered as forming part of the contract. For example, when it comes to leave, for example, these matters have been provided for. So if there's a contract between employer and employee, even if they don't negotiate on those matters, there are matters which have been implied by the Labor Act as forming part of the contract. And not only that, when it comes to the contract between a banker and a customer, if we take the banking and other financial deposit taking legislation, there are certain matters which have been implied. When it comes to, let's say, land transactions, right? When it comes to land transactions, you have a lease between the lessee and the lessor. There are certain covenants, certain obligations, which are implied. In other words, the lawmaker says that they should be form part of such a transaction. So those are examples of terms that are implied by statute. And again, apart from terms implied by statutes, the court may also imply terms in order to give what we call like the business efficacy. What do you mean by that? The parties have made the contract. They have made, they provided for certain terms themselves, but what they have provided for, if they are taken at just face value, without implying or reading certain things in what they have done, the contract will be unworkable, and the intention of the parties will be defeated, as the contract will not be workable. So in order to make the contract workable, in order not to defeat the intention of the parties and rather to effectuate it, the court may need to imply terms in order to give like the business efficacy to it. And you know the famous case of a Moorcock, the Moorcock case, for example, about the yacht, which was the vessel which was supposed to be actually parked at a particular jetty in the River Thames, and there was this argument as to whether it was the responsibility of the person who was in charge of where the vessel was supposed to dock or park to alert the one who was bringing the vessel as to whether the water level at the place where the parking would take place, for example, was in order not for the vessel to sink and sit on the seabed or the riverbed. In case there's any rock there, it could get damage. And the court will look at all that and say that if you look at the type of contract that they entered into, if you look at the obligations involved, despite the fact that expressly there was no obligation to that effect as to the owner of the jetty having to alert the guy bringing the vessel regarding the tide or the level of the water. In order not to defeat the intention of the parties, the court was prepared to read an obligation on the part of the owner of the the place where the vessel was going to dock or park as his responsibility to alert the vessel owner as to the level of the water, as it were. And sometimes it's not only having reference to what we call like the business efficacy, as you saw. There may also be what we call like the obvious omissions, which are seen in the contract, and where those omissions, for example, the court will say that if a reasonable person's attention was drawn to the fact that, but these parties have omitted this, you have just have said, yes, of course, these are also meant to form part of. So just trying to fill obvious gaps or obvious omissions, which will be interpreted as being, if you like, an oversight, if you like, so to speak, on part of the parties, and that if the attention had been drawn to it, they will have readily agreed, and so on. Okay, so apart from classifying terms as express or as implied, terms are also of different weights or different importance. So you may classify terms using the relative importance. And on that basis, it is important to remember that for a long time, the position of the law was that a term was either a condition or a warranty. A condition, as you remember, simply means that that term was of paramount importance, going to the very root of the contract. And that meant that if it was breached, that term was supposed to entitle the innocent party, first of all, to treat the contract as having come to an end, and secondly, to sue for damages. And so when we are discussing this charge of conduct, it's what they call a repudiatory damage. Okay, so the repudiatory damage here comes from breach of a term of conduct known as a condition, because the condition goes to the very foundation of the contract. And for that matter, when it is breached, the innocent party is given major remedies. And these remedies, as I said, include the right to treat the contract as having come to an end. The right to treat the contract as having come to an end. And not only that, to also sue for necessary compensation in the form of what we call like the damages. On the other hand, if the contract, if the particular term is not of major importance and is of relatively minor importance, when it is breached, the innocent party cannot treat the contract as having come to an end. So the breach should be what they call non-repudiatory breach. Non-repudiatory breach in the sense that you cannot terminate the contract. You cannot terminate the contract. So typically, the cases, as you remember, which are used to illustrate the case of Possard and Spears, and then the case of Bethany and Guy. So if you look at the Possard and Spears, you know it already. Because of time, I don't want to be discussing details of the cases that you know, but just to remind you that if you have, for example, a question and you have to distinguish between a condition and a warranty, it's not enough for you to tell us that a condition is a term of major importance which go to the root of the contract. You must go ahead and tell us the fact that when it is breached, the innocent party has a right to terminate the contract. And the breach is what we call a repudiatory breach. And secondly, the innocent party is entitled to bring action for damages. And thirdly, if the defaulting party should demand what we call specific performance, right? Assuming it's a type of contract, you can demand specific performance. Then the innocent party can put up the breach as a defense to any counterclaim or any action for specific performance. And of course, then you cite the contrasting case of a Pussat and Spears on one hand, and then a Bethany and Jai on the other hand. But the opera performance, you know these cases already. You have a limited time to let me belabor them. Now, in 1961-62, there was a case before the English Court of Appeal. And that case brought a new dimension. So instead of understanding terms of contract as either condition or a warranty, it brought up the possibility of a third categorization, so that there are certain terms which may be treated as innominate, also known as intermediate term, as it were. So innominate terms are neither a condition nor a warranty. So what are they? When there's a breach of innominate term, the remedy to be assessed or the remedy to be granted to the innocent party will depend very much on the nature or the severity of the breach, the consequences of the breach, so that the greater the consequence or the more severe the breach, then the innocent party will be given remedies which are usually given for breach of condition, and vice versa. That is to say that where the breach is inconsequential, the breach is not that severe, the innocent party will be given remedies which are given for breach of a warranty. So simply put, with respect to innominate term, and to use Lord Diplock's reasoning in the case of Hong Kong Fair Shipping against Kawasaki Kazan Kajal Limited, you say that you use what you call, like, you adopt the wait and see approach. What do you mean by the wait and see approach? That is to say that if you look at the contract, before a breach has occurred, you are not in a position to actually determine as whether a particular term is a condition or is a warranty, and rather need to wait for a breach to actually occur. And when a breach has occurred, then you assess or you weigh the impact of the breach on the contract, on the rights of the parties to the contract. If the impact is so severe in the sense that they actually undermine the rest of the contract, they undermine the rights of the parties in the contract, then you will say that the innocent party should be given remedy for breach of what? A condition, in which case the contract will be repudiated or terminated, and they'll be given damages for breach. On the other hand, if you weigh the breach and is so insignificant in terms of the right of the parties, in terms of the contract, then you give the innocent party remedies which are usually given for the breach of what they call a warranty, as it were. So please take note of that. So if you look at like the case of Hong Kong Fair, for example, if you look at the full judgment, you notice that a charter party have been given for a long period of time, but just for certain number of weeks, there had been a breakdown, and because of the breakdown here and there, the other party wanted to terminate the contract. Then when the matter came to court, the court looked at the breakdown of the vessel and compared it with the entire period within which the vessel is supposed to be in use and all that. And then the court took the view that the number of period, the weeks that we have highlighted the breakdowns about the 24 weeks period was insignificant compared with the number of the months, about 48 months, which the charter party had actually be given as it were. So the contract could not be terminated. Reflecting against that, when it comes to these type of terms, you cannot pre-classify until a breach has occurred. Then we also remember exclusion clauses, as we have talked about them when we're trying to explain the express terms. These are clauses which are put in the contract by one of the parties, usually a party in a stronger position, to try and either completely say that when I am in breach, I cannot be held liable for certain breaches or the whole of the breaches, as the case may be. And typically, when you have like a standard form contract, what they call the contract of adhesion, that's another name for standard form contract, you are likely to have exclusion clause. And like standard form contract, in case you are wondering what it is, those contracts where the terms are actually dictated by one party, and that party is usually in the stronger bargaining position, and the other party will have to take or leave it. So something we call the take or leave it contract. For example, you want to use MTN services. You go to MTN shop, they are giving you a whole lot of documents to sign, or when they send it on your phone, you have to click yeah, I agree or I don't agree. You cannot change even a word. Let's say they put in a clause that if there is any network interruption, we do not accept liability for any loss which you suffer and so on. They put it there. So that is a practical example of exclusion clause. Now, that type of contract is what is used for everyone. And that's what I call like the standard form contract. You accept it. But not only in standard form contract, except that exclusion clauses are more common in a standard form contract, as it were. Well, ordinarily, one would say that their purpose is to allocate risk between the parties. After all, contract is about autonomy, freedom. People exercising their freedom to contract or their party autonomy. So if they have agreed to share whatever losses or problem that may be occasioned, why not? But the real challenge is that in reality, exclusion clauses are put in the contract by the stronger party. And that is why it's a concern to the law, concern to the courts. The law is there to protect the vulnerable against the strong and the mighty. If we have a situation where exclusion clauses have been hammered out in a contract by parties of equal bargaining power, equal bargaining strength, that should ordinarily not be the concern of anyone. But oftentimes, they are included in the contract by a party in a relatively stronger position. And that is why the law has developed to check the use of exclusion, exemption clause, or limitation clauses in contracts. For that matter, the courts want to be very convinced that both parties actually agreed without one being bullied by the other, that the exclusion clause forms out of the contract. So where it is not, it's supposed to be in writing, for example, if your signature is there, then we can take it for granted that you have freely accepted that the exclusion clause will form part of the contract, as we saw in the Lestrade and Gracop. But of course, we have exception. Exception will be where your signature is there as a result of you having been deceived fraudulently, as happened in the Curtis against the Chemical Cleaning and Dyeing Company. Then, despite the fact that your signature is there, you will not be held to the exclusion clause. Now, where the exclusion clause is not contained in the writing, which requires signature, then the reasonable notice is supposed to be given. It's supposed to be given to the other party against whom is going to operate. So you typically go to, let's say, the car parking, right? You go to parking areas, either a public place, a car park, or airport car park, or wherever. And you see signs written there that no vehicles are parked here, no, at the risk of the owners, and management of the car park will not accept any liability, and so on. So that is some example of what exclusion clause. But as I said, the authorities are there. Reasonable notice should be given to the other party regarding existence of this exclusion clause before or at the time that the contract is going to be made, and not after. So the stage at which the notice was brought to the attention of the other party is important. If the notice was brought to his attention after the contract has been made, then the exclusion clause cannot form part of the contract. But if it was before or at the time of making the contract, then it will form integral part of the contract as it were. And the car parking example, we know the case of a taunting against the shoe lane parking. And as you know, over there, they have like automated system. If you park your car, then you are given a ticket, and the ticket will say that conditions displayed inside the premises are the conditions on basis of which you have parked your car, and it included an exclusion clause saying that no liability will be accepted for personal injury. And if later on, when an injury occurred, the court took the view that the exclusion clause was not properly incorporated, because when you entered and you press the machine, the automated machine, you are given the receipt, and the receipt refers you back to terms and conditions which are stated on the premises that you are here to enter. So where was the contract made? If the contract was made at the point that you were given the ticket, then you were not aware of those conditions. So the timing is very important. Just like chaplaincy against the bar, you see that one too. As you remember, the exemption clause was at the back of the receipt or ticket, and the court took the view that the contract was made before the person became aware of those exemption clauses, as it were. We've also seen how course of dealing may be used as a basis of holding that exemption clause or exclusion clause was incorporated into the contract by the parties. But from the case law, the course of dealing should have been consistent, should have been frequent, and it does not appear that an isolated course of dealing will suffice for the court to say that there's a course of dealing on basis of which we can say that a particular exemption or exclusion clause is part of the contract that the parties have made. So let's keep that in mind. Now, having satisfied the requirement of incorporation, having demonstrated that yes, the exclusion clause or the exemption clause form part of the contract. The other thing we need to be worried about is about interpretation. Where there has been a breach of the contract, the other party in whose favor the exclusion or the exemption or the limitation clause was incorporated in the contract may want to take a refuge or cover under this particular clause. It may well happen that the clause may not be that clear in terms of meaning and scope. So we need to construe, we need to interpret the clause to find out whether the clause actually covers the particular breach which has occurred. If it covers the breach which has occurred, then it will operate to the benefit of whoever is supposed to benefit from it. On the other hand, if the construction of it turns out that it does not cover the type of breach which has occurred, in that case, whoever is supposed to benefit from it cannot benefit from it, and you still have to bear the liability for the breach which has occurred. And that is why the construction or the interpretation is important. And for that matter, where you have a question, let's say that you have an examination question, which is asking you to discuss how the courts actually control, or let's say how the law, not even like how the law control the use of exemption or exclusion clause. Now, you need to look at two sides of the matter. The first aspect is the requirements of incorporation, trying to find out whether the exemption or the exclusion clause actually forms part of the contract. So how do we determine that? And that is why we have said that where the exclusion or the exemption clause requires signature of the parties, then the fact that you have signed is enough indication that it forms integral part of the contract. So that is the general position. The only exception will be where you have signed, but you did so as a result of fraudulent circumstances, in which case you will not be held to it. And again, we've also seen the fact that where it does not require a signature, then reasonable adequate notice should be what? Should be given to the other party. And this notice should be given before or at the time and not after. Now, when you have finished with this first aspect of the question, then the second aspect will be the fact that even where it has been established that the exclusion or the exemption clause form part of the contract, the court will still subject it to interpretation to find out whether the clause actually covers, the scope of it covers or encapsulates the particular breach which has occurred. Now, and the question is, how do the courts go about interpreting or construing exclusion or exemption clause? So we have the well-known contra proferentem rule. Contra proferentem rule. And the contra proferentem rule simply means that any ambiguity in an exclusion clause will be interpreted against the party relying on it. So if there's ambiguity, if the exclusion clause, for example, can be understood in more than one sense, can be understood in 2 or 3 or 4 senses, and one of the senses or one of the meanings, for example, is very narrow, and if that is adopted, it's going to be to the disadvantage of whoever was supposed to benefit from the exclusion clause. And the contra proferentem rule says that the court should prefer the most narrow or restrictive interpretation, which will be to the detriment of the person at whose instance the exclusion or exemption clause was included in the contract, as it were. So there are a lot of cases, as you know. So like the Andrews brothers against a singer, for example, the contract provided for sale of a new Singer cars and included a clause which was to the effect that, excluding all conditions, warranties, and liabilities implied by statute, common law, or otherwise. So the car delivered was not new, and the court took the view that the exclusion clause did not cover the specific obligation to deliver a new car, and the seller was therefore liable. So the point being made is that anytime you have ambiguity means that the particular clause is capable of bearing more than one meaning. And since the meaning is more than one, certainly they will not be the same. One may be more liberal, one may be more encompassing. That is to say that I can cover so many things, including even like the breach which has occurred. And one meaning may also be very narrow in terms of the scope. Then contra proferentem says that the court should prefer the narrow interpretation. Of course, when it comes to liability for negligence, where the exclusion clause seeks to exclude liability for negligence, there must be no ambiguity whatsoever. If there is any ambiguity, the courts would take a stand against it, and for that matter, it will not inure to the benefit of whoever is supposed to benefit from it. So if you look at the Canada steamship lines against the King case, for example, the plaintiff's goods were damaged in a fire caused by negligence of the defendant's employees, and there was a clause excluding liability for damage whatsoever cause. Look at it, whatsoever cause. And the court needed to find out whether the exclusion clause, which says that there's no liability for any damage whatsoever clause, does that extend to the fire, which had been caused by the negligence of the defendant's employees. If it did, then the defendant could not be held liable for the fire and the damages that it has caused. Now, the court proposed a certain test that we need to find out. One, does the clause explicitly mention negligence or synonym? If yes, then it likely covers negligence. Two, if not, is the language wide enough to cover negligence? If yes, the clause may still apply. And three, is there an alternative ground of liability other than negligence? If so, the clause is presumed not to cover negligence. But if you look at the circumstances of the Canadian steamship case itself, the court took the view that the clause did not really succeed in excluding liability for negligence. The reason being that there was an alternative ground of liability. And that was a breach of what they call the statutory duty. There was a law which actually made it mandatory, not for you to cause the damage or danger which has occurred by negligence. And that is a statutory duty. And for that matter, the court took the view that the exclusion clause, quite apart from not mentioning the word negligence, did not actually cover the breach which had occurred. So the point or the takeaway is simply that when it comes to interpretation of exclusion, exemption clauses, limitation clauses, the courts are quite strict. The courts are quite strict, and they take very restrictive approach. I think that is what you should keep in mind. And then there's also what we call the doctrine of fundamental breach, which is used to be a big deal as far as exclusion clauses were concerned. And initially, there was this concern as to whether exclusion clauses could not cover fundamental breaches of contract. When we say fundamental breaches of contract, where there has been a breach of, let's say, a condition. When there's a condition, that is fundamental breach in the sense that it's a repudiatory breach. It entitles the innocent party to terminate the contract. So there was this debate as to whether exclusion clause could actually cover it or could not cover it. But all the long line of case law, which said yes, fundamental breach did not apply to exclusion clause. Fundamental breach was applicable, as all those case laws have actually given way to a very simple position now that you don't have to have a hard and fast rule as whether the doctrine of fundamental breach applies to exclusion clause or not. It's a question of construction. It's a question of interpretation. Now, when you interpret the particular contract and look at the facts, what does it say? And that position was advanced by the UK House of Laws in Photo Production Limited against Securico Transport Limited. As you remember, there was a security company, that's a defendant security company, and they provided the night patrol services for the plaintiff's factory. So one of their security guards who had been posted to work there started the fire, and the fire caused extensive damage. However, if you look at the contract between the security company, that's like the defendant, and also the plaintiff, there was a clause to the effect that the defendant liability for any loss was limited. If you read the full case, how the clause is actually catch is very elaborate. So the question is this: why do you have a security company patrolling your premises? Because you want the place to be safeguarded against theft, safeguarded against any arson or any distraction, as it were. But then, where you have a scenario where the security company is saying that, well, we had a clause that we've excluded the liability for, or we have limited the liability for any loss arising and so on. Does that mean that the security company does not have obligation to really safeguard the premises against certain types of avoidable losses like maybe fire and damage, fire which is not accidental, but is actually intentionally or negligently caused by staff of the defendant security company. So it was within that context that the House of Lords made the view that the exclusion clause in that particular case was valid, despite the fact that the breach was fundamental. Because in the thinking of the court, the parties had clearly agreed to limit liability in such circumstances. Now, previously, the fundamental breach doctrine would have been flagged to simply say that because what had happened was so fundamental, then exclusion clause would not apply to exculpate the defendant from liability. The court said that is not the way to go about it. We need to interpret the clause holistically. And when that was done, the court took the view that it was applicable to an extent. So the most important thing to observe from here is that there has been a shift from the doctrinal position that automatically exclusion clauses are not applicable to fundamental breach. Now, the court said that it's more a question of interpretation, construction of the relevant document as it were. We have questions on this, but okay, we jump and look at those questions before we come to look at the capacity. But if you have questions, you can also bring them up. Sorry, before we come to look at the illegality, yes. But if you have questions, you can also bring it up and then we'll discuss it. If there's anything that is not clear to you or you want to see further elaboration. But make sure you put your hand up so that only one person will be talking at a time. In terms of like the essay question, I think pretty straightforward. Discuss the significance of the distinction between conditions and warranties in contract law, using relevant case law to support your answer. So if you have a question like this, discuss it already. The answers will tell us briefly what terms of contract are, briefly. And then you go straight to the heart of the question. That terms of contract may be classified according to the degree of importance. And on that basis, terms of contract for long term were seen as either a condition or warranty. I'll explain what the condition is. You give example, case law illustration. You explain what the warranty is. You give a case law illustration. And then you tell us what is the main distinction, and then what is the significance of the distinction. So the main distinction, as we have said, the fact that where condition is a breach, it creates the right to terminate the contract, the right to sue for damages, the right to set up the breach of the condition as a defense to any action for specific performance which may be brought by the defaulting party, as it were. On the other hand, for warranties, as we know, it does not entitle you to terminate the contract. The contract will have to continue. You have to continue observing your obligation under the contract, except that you can sue for damages for the breach which has occurred. Then you come to say, what is the significance? So terms are classified as condition or warranty to let us know what remedy to give, because the two terms are not of the same importance in terms of the particular contract. So therefore, where there's a breach, the consequences are different and the remedies are different. And that is why we have the distinction. So very straightforward. Two, explain how court determine whether an exclusion clause has been validly incorporated into a contract with reference to cases, key cases.
Recording in progress.
Yeah, so very straightforward again. To tell us what the exclusion clause is. And having told us what an exclusion clause is, there's a feedback here. Jennifer, you want to ask a question or make a contribution?
No, my lord.
Right, okay.
Okay.
Yeah, so you explain what exclusion clause is, and having explained what it is, you need to make the point that exclusion clause is generally frowned upon by the law because it suggests that a person in a stronger bargaining power or position is exploiting a person who is vulnerable in a contractual arrangement. And for that matter, the courts or the law needs to ascertain as whether it was really integral part of the contract. And how is that established? You go through what you've gone through, where it requires a writing, as we've talked about, the signature of the parties, the exception, where it has not required a signature of the parties, but then it's in writing, the reasonableness of the notice, as we have discussed. And when you are done with that, the question said whether has been validly incorporated into the contract. So the interpretation bit is not what is being examined. So you don't need to waste time discussing the interpretation bit. It is different if the question said that discuss how exclusion or exemption clause is regulated under Ghanaian law, in which case you have to look at the requirements for valid incorporation and also talk about requirements for interpretation. But if the question just said incorporation, maybe out of abundance of caution, just 2 or 3 lines, you may throw in what you know about how it's interpreted in order to ensure whether it covers particular breach, but that is not the real heart of the question. But one thing examiners want to observe is that for essay questions where some students, where they are not too sure, then they will rather go to town and present every information to the examiner, for the examiner to pick what he or she is looking for. It's not a good practice, but sometimes if you cannot help under desperation, it's better to do that than to fail the particular question. Okay, so let's look at the one problem. Let's say Kwame, a haulier, enters into a contract with Kofi to transport a load of yams from Kofi's farm in Eastern region to Accra market every week for 10 weeks. The agreements include the following terms. The deadline to catch the market is 6 a.m. Monday. It's a condition of contract that the truck shall be at the farm, ready to load by 3 p.m. every Sunday. And that the vehicle shall at all times be in a good roadworthy condition. So this is the term. On the first Sunday, the truck did not arrive at the farm until 3:05 p.m. because the driver got lost. Nevertheless, the truck was loaded and dispatched in time to reach the market. Later that same day, it suffered a mechanical breakdown, causing it to miss the Adome Bridge ferry, but the driver managed to catch the next one and through some hard driving, reached the Accra market on time. On second Sunday, the truck was punctual and made the trip without any issue. However, on the third Sunday, the truck had another mechanical breakdown on its way to the farm and arrived at 3:30 p.m. The driver assured Kofi that the problem had been resolved and that he could still catch the ferry. But Kofi sent the driver away and called Kwame to inform him that the contract was cancelled. Okay, so advise the parties. Will anybody try? As we have indicated, if you have a problem-based question all the time, it is safer to be structured in your approach. And being structured in your approach means that you have to use the IRAC or the IPAC. You have to identify your issues. Some may add identification of area. If you add it, that is fine. But if you don't add it, you don't lose anything. So identification of issues or together with your area, and then you take each of the issues one after the other. You state the principles, including the authorities or case law for those principles, and you do your analysis and application to conclude on that issue, and then you repeat that for all the other issues, and you draw your bigger conclusion. So that is the IPAC or the IRAC approach. And as I said, if you get any problem-based question, not only in contracts, whether in tort, criminal law, land law, it is useful to be structured and think like how legal problems are resolved in real life. Good. So Afonso indicated that go through your hypothetical facts line by line quickly so that you can get the sense of what is expected of you. So having read the story the first time, what do you think is the area of the law? What do you think is the area of the law? Not be interactive. Okay, then let me just talk to you and then I'll go. Okay, so we move on to illegality and public policy. So illegality and public policy, the point to remember is that contracts are considered illegal where they are made either in violation of a particular law. The law says I cannot make that contract. Or in carrying out the contract, you may be breaching a particular law. Or sometimes a contract which was quite lawful at the time that it was made subsequently become illegal because there has been a change in the law or government policy, as it were. And the position of the common law is that the court will not assist a party to enforce an illegal contract. And traditionally, the orthodox position of common law is also that a party cannot recover benefit under illegal contracts or contracts which are contrary to public policy. And you know the famous maxim, "S tupicus non orito actio," no action arises from a dishonorable cause or a base cause, as it were. So there are various categories of illegal contract. As I said, we have contracts which are prohibited. That is to say that the law says that either expressly or implicitly, impliedly, you cannot enter into that type of contract. Can anybody give an example of contract which by specific legislation in Ghana are not permitted?
Hello, hello, His Lordship.
Yes, proceed.
Please, I would like to know whether RT Briscoe versus ACN will do.
So what is the law, the specific legislation?
Okay, His Lordship, please, at that time, the defendant contracted the plaintiff for some redwoods. At the time the contract was being made, it was legal for redwoods to be sold. However, after the contract was made, a law was made prohibiting the sale of redwoods, so it made the contract illegal.
Okay. So any other modern example, like any specific legislation which actually prohibits the making of contract?
Okay, His Lordship, please, contract against corruption and public policy. So if one uses his public office for his personal benefit, I think the Criminal Act, please, the section I've forgotten a bit, makes it illegal.
Okay. So what about okay, there are some examples which I was going to give, but because of certain matters which are sub judice, I've just restrained myself. Yes, so that is fine, but there are a lot of more direct example. But anyway, okay. So if you have like a particular transaction which the law requires that you cannot do it unless you have a license, and let's say that you enter into that contract without the license, then automatically, because the law says that you must have license before you can enter into it, that contract is void ab initio. It's illegal at this very inception. And that is what the case of Ray Mahmood and Ismahani illustrates. The plaintiff contracted to sell linseed oil to the defendant, and it was a requirement that you needed to get a license before you could deal in linseed oil because of the the wartime condition. The First World War was still pending, and eventually the court took the view that the contract was illegal at its inception, and for that matter, it was void because it had been made in violation of what of a statute. You look at in Ghana, we have our Gaming Act, UK to the how like the Gaming Act. If you take the National Lotteries Authority, for example, the Lotteries Act, and it is a requirement that before you can engage in lotto business, gaming, you must have a license. You must be regulated by the regulator, the Gaming Commission, the National Lotteries Authority, and so on. So where, for example, you engage in, especially in Ghana, what do you call it, the banker to banker, all those things. If you are not given the necessary, permit, if you take people's money and they win and you don't pay, it goes to court and all that, the court cannot assist the person who has won the lotto, who did not purchase it from either the National Lotteries Authority or from a licensed or authorized person to actually recover the win because the transaction was illegal to start with. Then we also have contracts which are illegal at common law are considered as being contrary to public policy. For example, you enter into contract, to commit a crime. He mentioned bribery and corruption. That would be like a good example. Or you contract someone to go and do something which is illegal, to kill another person or to do some other things. All those things at common law are considered as being contrary to public policy. For that matter, it is void as it were. We know the old case of Foster and Driscoll, for example. You know it from your LLB days. Those who like whiskey, there was a contract to smuggle whiskey into US, and at the time that this contract was made, there was a strict prohibition regime in force. So the court eventually took the view that the contract was contrary to public policy because it also sought to commit a crime in a foreign country. So that is another thing. So where there's also a contract for you to commit a crime in a foreign country, especially where the country is not at war with Ghana, that would also be considered as being illegal as it were. We also have contract against public morality, as you know. And typical example which comes to mind is maybe contract which encourages immoral behavior. You enter into, you can think of, in Ghana, for example, we haven't legalized prostitution, as it were. So if there's any contract in that particular context, that is contrary to public policy because against public morality, as it were. Remember the well-known case of Pierce against Brooks. Pierce against Brooks. And it was in that case that Lord Mellish also made his famous statements regarding public policy that is like the unruly horse. Once you astride on it, you don't know where it will take you, as it were. And again, the similar, Pierce and Brooks, similar to that. That's about the the property, a carriage, which had been led to prostitute, and it was known that the prostitute was going to use it to attract his customers. Eventually, there was a default in payment. The matter came to court, and then court said that since the contract was seeking to promote immorality, the court will not assist its enforcement. And similar thing happened in Upfield and Right, as you know very well. Again, contracts which also, yes, Magnuson.
Hello, His Lordship.
Yes.
Yes, please. I would like to know in the case of Pierce and Brooks, please, assuming the defendant made a claim that he didn't know that the coaches were being hired for the advances of prostitution, could the case that had gone in his favor?
As you said, if you had made the case, can you?
He didn't know that they were going to use the vehicle for prostitution.
Okay, but you see, it's not a question of the court will look at the entire evidence. If the evidence clearly shows that there's no way that you knew or could have known, then you didn't know. But in this particular case, the evidence was different. So you are right. If you get a scenario where there's no evidence whatsoever that you knew the object or the purpose or which the carriage or whatever was being let was going to use for maybe prostitution or some illegal thing, then that is a different matter. It's just like you're someone who deals in arms and ammunitions. And let's say you sell arms and ammunitions for gaming, that's for hunting purpose. You sell it and then someone should use it to go and commit a robbery or go and kill a human being and all that. Certainly, if, for example, you had not finished paying for it and you defaulted in paying, he sues you, you cannot bring up the argument of the contract being contrary to public policy because it was seeking to enable you to go and commit a robbery or go and commit murder, because that particular thing is sold for hunting purpose and he sold it within that particular context. Yeah. So it's very much dependent upon the peculiar facts before the court. So for matters like this, you cannot make too much generalization. You have to look at a particular set of facts. And then on case-by-case basis, you're able to give various determination, as it were. Again, we also have contracts which are prejudicial to public safety or administration of justice. And we know if any contract which, for example, seeks to interfere with the ability of the court to administer justice or which seeks to undermine public safety, all these are considered as an illegal contract, which are contrary to public policy, as it were. So the examples that our friend gave concerning contract to bribe, the contract to corrupt, and all that, all those things are meant to undermine or interfere with administration of justice, and that is wrong and it's illegal. But before we, I'm sure you've heard of what they call the ivory, Scott and Ivory, where you have a contract which seeks to oust the jurisdiction of the court. A contract which says that, yes, we have our own dispute settlement and no court is allowed to intervene in our matter. As common law, no one can contract to extinguish jurisdiction of the court. the courts are there to adjudicate cases. So if you make your private contract, you can decide to make a provision for your own internal dispute settlement mechanism and say that that will have to be exhausted before the regular courts may be resorted to. But you cannot say that you have completely ousted, completely prevented the court from intervening in dispute arising under the contract. Yeah, so that is what we call like the ivory clause, or Scott and ivory. There's a contract which said that yes, before you go to court, a certain internal dispute resolution mechanism should be used. Then the court said that you can delay the intervention of the court by saying that you should use your own internal remedies, internal dispute settlement mechanism. But you cannot completely say that the courts are prevented from having anything to do. So let's keep that in mind. I notice some of you have things to. Yeah, okay. So, yeah, Kisi and Chairman, yeah, that is true. The Liberian ambassador. So where we have a determination that yes, there has been an illegality or contract was made illegally or contrary to public policy, what happens? Well, if the contracts are illegal, then as far as the law is concerned, right from the very beginning, the inception, when it was thought that a contract had been made in the eyes of the law, and no lawful contract existed. So the contract in the eyes of the law did not exist. It is void ab initio, as it were. And if it's void ab initio, it does not create right or obligation for anyone. No one can enforce it. And you cannot recover no benefits under it, as it were. But the rule that the court will not assist a party to recover money or property transferred under an illegal agreement is not an inflexible one. In other words, there are exceptions. There are circumstances under which some limited recovery may be allowed under an otherwise illegal contract or contract which is contrary to public policy. So, for example, one exception is where you can recover without reliance on the illegal contracts. Where money transferred or property transfer can be recovered without you basing yourself on the illegal contract, then that is permissible. So if you look at the Bowmarks limited against the Barnett instrument, as you remember, the contract there was about the letting of machine tools under high purchase arrangements with the defendant. But that was in contravention of wartime regulations, the Second World War. And the courts, having looked at all the circumstances, to the view that, yes, the plaintiff could recover the tools because they base their claim on ownership rights, not on the illegal contracts. So they were not, the tools are behind, yes, there being a default and in paying and all that. Now, quite apart from saying that you are in breach of the contract, so give the tools back to me, they could also establish that they were the owners. And in that case, you can come under no thoughts you can come under tort and some other legal regime without necessarily basing yourself on the contract, which is illegal. Another exception is where the parties are not in pari delito. That is to say that the parties are not equally at fault. We have an illegal contract. The contract is illegal or contrary to public policy. But when it is considered, it is clear that one was not blameworthy for the illegality like the other. So where they are not equally at fault, where they are not in pari delito, the person who is the less guilty party or the relatively innocent party, as it were, may recover whatever money that he might have lost under the contract, as it were. And you remember the case of a Kiruri cotton against Diwani? And again, where there has been change of mind and heart, what we call the locus penitentia, where there has been a repentance, a party to illegal contracts repents and withdraws from the illegal contract before performance, then he or she will be allowed to recover because of the change of mind, because of the locus penitentia, the repentance. So cases like the tribe and so on. Yeah, so I've discussed the contract seeking to oust the jurisdiction of the court, and you've made the point that that is not permissible. However, where it is meant to delay the jurisdiction of the court, then that is permissible. So we don't believe that. But there's a particular thing I always ask students to look at. The case of City and Country Waste Limited against Accra Metropolitan Assembly. And that case represents the current position of the law in Ghana as far as recovery of money or property transferred under illegal contract is concerned. So every year, I ask students to read that case. If you want to answer a question on illegal contract or contract, contrary to public policy, especially when it comes to transfer of money under that contract. And in that case, as you remember, and I've told you about it before, that there was a contract, for provision of sanitation services by the Accra City and Country Waste Limited on behalf of Accra Metropolitan Assembly. So they did the service, but the AMA defaulted in paying, and then when they were sued, they put up the argument that they had not complied with the statutory procedure regarding how such contracts should be awarded under their local governance system. So in effect, they wanted to say that the contract we did with you was illegal, so we cannot be held to pay money under illegal contracts. That will be contrary to our statute. So that was a rare difficulty because the service had been provided, the AMA had benefited from it. Now, if you are to apply the strict common law approach and say that, yes, monies transferred under legal contract cannot be recovered unless the parties are not in pari delito unless there has been repentance or local penitentiary, or unless you can recover it without basing yourself on illegality. You are going to have a rare difficulty having regard to this particular factual circumstances. So the Supreme Court, speaking through Justice Dr. Dateba, made the point that the law on recovery of monies or property under illegal contracts should also be appreciated from the point of view of the law against unjust enrichment. Unjust enrichment meaning that if you look at the story before us, EME has benefited from the sanitation provided by CCW Limited for all this period. And if nothing is done, then EME had enriched themselves at the expense of the CCW. So the court said that we should have a structured approach, so that in deserving cases like this, for example, the plaintiff had no control whatsoever regarding the particular illegality which the AMA was seeking to point to. And for that matter, the court allowed the recovery to be done under those limited circumstances. Yeah, so if you want to answer a question on illegality and public policy, please look at that case so that your response will be rich. Of course, if you have a contract which is prejudicial to status of marriage, that one is also contrary to public policy, as you know. Now, let's talk about contract and restraint of trade. Contract and restraint of trade has to do with placing a restriction on a person's ability to engage in business or employment. And the law considers such contract as void, because everyone should have the ability to earn his or her living, either by running a business or offering his labor services in an employment arrangement. So if there is any contract which seeks to prevent a person from being able to do that, then that is considered void. The caveat is that if such a contract is made in order to protect legitimate interests of the person who is seeking to restrict the ability of another to engage in business or employment, then so long as such a contract considered as being necessary to protect the legitimate interests of that person will be allowed. And question is, how do we know whether it protects legitimate interests? The court will look at it from the reasonableness of the restriction in terms of the scope. How wide is the restriction? If the restriction is wider than what is really needed to protect your interests, then the court will not consider it as legitimate to strike it down. The duration, the restriction must have a sunset clause. It must come to an end at a certain point. And if the duration is in excess of what is really required to protect your interests, that will also be struck down. And thirdly, the geographical scope of the restriction. For example, if you have placed a restriction that someone cannot do particular business or particular work in the whole of Africa or the whole world, that may be struck down as being unreasonable and not actually advancing the legitimate interest of the person. You know the well-known case of Nordenfeld against Mazem Nordenfeld Guns and Mission, where the House of Laws upheld a worldwide restriction on a seller of a business. What business was that? What business? What type of guns?
I think guns and ammunition.
So why did the court uphold it?
Okay, His Lordship, I believe the court upheld it because they believed it was reasonable due to the fact that the defendant had got to know some trade secrets, and then also was in possession of some key customers' information.
Okay. And then what else? You know, we're giving a test. You're giving a test. So which aspect of the test was also relevant? What was the duration?
Yes, please.
Okay. And also Suez Petroleum against the Harper's Garage. There was what you call like the Solos agreement, or what you call the exclusive dealership agreement. Okay, 25 years. Okay. Yeah, somebody has put it in the chat. I'm sure you saw it. So the point to note is that when it comes to contract restraint of trade, first of all, is considered as being contrary to public policy because it seeks to hurt the ability of a person to earn a living by carrying out a business or by taking up employment. Nevertheless, the court also, or the law, recognizes the need to protect the legitimate interests in what you call the free competition and also creativity. Those of you who've done the intellectual property law, you appreciate what I'm talking about to some extent. So where people have invested into their businesses, employment, and all that, then they should reasonably expect that they'll be able to benefit from it for a reasonable period of time without they losing out in a competition and all that. And that is why a stringent test is set that yes, contract in restraint of trade, whether with respect to employment contract or with respect to sale of business, will be determined according to the reasonableness test, the geographical scope, the general scope of the clause, the duration, and all that. So all these are matters which will weigh on the mind of the court in trying to determine whether particular contract in restraint of trade or contract in restraint of employment is reasonable or not. Let's look at the so if you have like analyze the impact of public policy on enforceability of contract using examples from common law and statutory provisions. So this is a very a free range type of question for you to go to town and provide exposition of your knowledge on the consequences of illegality And let's come back to the question. The questions. So let's say Daniel enters into agreement with Ima to pay her amount of money to refrain from marrying anyone else. Ima later marries another man, and Daniel seeks to enforce the agreement. So you have to advise or discuss the enforceability of this contract. Very straightforward. Will anybody give it a try? Anybody?
Okay, His Lordship, please, I'd like to try. Contract, sorry, the area of law would be consideration.
Why consideration?
Okay, sorry, please. Contract against public policy.
Okay. Okay. I do know something before our friend will continue. Let me comment on something based upon certain advice we'll be giving you. You see, when I ask what's the area of the law, you quickly mentioned, let's say, consideration. So let's assume that in the marking scheme, which your examiner is using, the area of law stated there, there's no consideration in it. As soon as you put that one there, you'll be marked wrong for that aspect, you see. But then if you had raised your issues, and then the issues that you have raised, they fall within the issues that can be raised, you get to a max. But so what are the issues? Yes, you can continue. What is the issue?
Okay, His Lordship, please.
Okay.
Whether or not Ima's contract with Daniel not to marry anyone else will be or can be enforced in the court of law.
Okay. All right, that's a good attempt. Yes. The other person, just a second. Yes, you can talk.
Okay, thank you. So I also try whether the restraint of marriage clause is unlawful.
Restraint of okay, usually when it comes to the contract if you use like the restraint, yeah, I get what you mean, but I just want to say that sometimes certain words or phrases, they are used for certain fixed ideas in the law. As soon as you mention the restraint, once you go to contract in restraint of trade, or which is a contract in restraint of trade means one of two things: contract in restraint of employment or contract in restraint of a sale of what of business, as it were. But here you are talking about the contract which seeks to prevent her from marrying. Is that not the case? Or you're talking about the restraint of trade?
No, please, that's the case. The restraint to marriage.
To marry.
Since
Okay.
we can't restrain.
Good. So I think the issue is very straightforward. It's one. And so having identified it, you tell us the law. You tell us the law, and then you do your analysis and application. Yes, Magnus, Sen.
Okay, His Lordship, please, you said the issue is just one. I would like to know whether we can raise another issue, such as whether or not the 10,000 paid by Daniel to Emma is recoverable.
Oh, all right. Okay. So that is the, all right. Yes. Yes. So that is fine. So now we are breaking the issues down so that you don't lose any aspect, which is good. Yes. So what is the law?
Okay, so His Lordship, please, generally under common law, contract against public policy is unenforceable. Cases such as Kisi versus Shamant, RT Briscoe versus ACN, Ampofo versus Fiorini would do say. Hello.
Yes, okay, thank you. Yeah, Jessica.
Okay, so I would also go like under the Ghanaian law, maybe an agreement to refrain a person from marrying can be considered unlawful and against public policy. And then indicate that maybe such agreements are void and they infringe upon the fundamental rights of a person to marry. Maybe I'll indicate some provisions in the Constitution to back it. And maybe probably mention, I don't remember the case, but probably look for some cases that would work with it. I don't know if I'm correct.
All right, okay. Yes.
Maybe you can use Lowry and PS.
What happened?
There was an agreement by a man not to marry anyone except a particular woman, and it was held to be void and against public policy.
Okay, good. Okay, good. So let's look at the other one. Frank, a supplier of medical equipment, agrees to sell a machine to George with knowledge that George intends to use it to produce counterfeit pharmaceuticals. George fails to pay, and Frank seeks to sue. So advise Frank on his legal position. Any attempt?
Okay, so His Lordship, please, the area of law is contract against public policy or illegal contract.
Yeah. Okay, so what's the issue?
Okay, so His Lordship, please, whether or not the agreement for the supply of medical equipment to Frank is enforceable.
Okay. Okay, that is fine, but I will allow you to break it into two, as you did previously.
Okay, and then issue two, whether or not the money paid by Frank to George is recoverable.
Okay. Okay, that is fine. So, wouldn't you have said that whether the agreement to sell the machine is contrary to public policy, whether it's illegal or contrary to public policy, you can just flag it. And if it is illegal or contrary to public policy, can the money, can the unpaid, what do you call the price be recovered? Because you need to establish whether it is contrary to public policy or illegal before you worry yourself as to whether if money is supposed to be paid, whether the money can be recovered. And that is why I prefer that you do the two. Because you need to conclude, yes, is it contrary to public policy? Is it illegal? If it's contrary to public policy or illegal, then the next question is, if money is supposed to be paid under it, can that money be paid? Can that money be recovered? Yes, any question from you? Any generalized question before I sign off?
Okay, thank you so much, His Lordship. And we really appreciate your effort in doing this for us yearly. Please, I would like to know, as you just taught us, that generally at common law, any contract to oust the jurisdiction of the court is void. And so please, I'm just thinking aloud. The entrance exams law students are made to write, whereby they are made to sign a declaration that after the exams, no one will challenge the result. Please, I would like to know whether it amounts to ousting the jurisdiction of the court. Thank you, His Lordship.
Thank you. You know, questions like this, you are asking it to the wrong person, isn't it? Maybe your other lecturers, you can ask it, you can pose that question to them, but not me. You know, for obvious reasons, isn't it?
Yes, His Lordship.
You agree? All right, thank you.
Thank you, sir.
Later, you have a question?
Oh no, I was thanking you for giving us this lecture, please.
Any question or before I sign off?
Okay. His Lordship, please, one last one. Please, I learned in the financial industry, when you are dismissed, normally they circulate as in your details among the financial institutions, whereby no other financial institution would hire your services. So I would like to know whether that does it infringe upon your right to work.
All right. Okay, good. I think, like, for example, like the Bank of Ghana, they have this thing they call the fitness, fit and proper test and all that. Good. So, where, for example, you'll be terminated, especially if it has to do with fraud or some other financial impropriety, the information is supposed to be shared within the financial community, especially the regulator, Bank of Ghana. Because you become like a high risk person, it doesn't mean that you cannot be employed. You can be employed, except that you'll be subjected to more scrutiny to make sure that you don't repeat whatever you are alleged to have been involved in. Yes, my friend, I don't know if that assists you, but that is how it is.
Okay, sir. Please, I'm okay, sir. Thank you, His Lordship.
So I wish you all the best. We are still praying for you. We'll come out. We'll come online again. Have a good night.